Good evening and welcome once again to another program of Issues in the News, where we discuss the important events that would have taken place in Guyana over the past week or so. And as usual, we always have a multiple of issues of importance to discuss in any given week. I want to begin, as I usually do, by welcoming our viewers who are joining us on television in region number 5, West Coast Berbice. Welcome to another program of Issues in the News. To our viewers who are joining us on television in region 6, East Coast Berbice, New Amsterdam, and all the way along the Quarantine Coast, welcome to another program of Issues in the News. To our friends who are joining us on Freedom Radio, welcome to another program of Issues in the News. And last but not least, to the thousands of you who are joining us on Facebook Live right across the length and breadth of Guyana, the Caribbean, North America, Europe, and even further afield. Welcome to another program of Issues in the News. Please share this program, share this live, share this podcast with all your friends. Press that share button on your phone. Press that share feature on your computer. Share it on your whatever device that you're using. Share this program so that all your friends and all the persons on your account and on your page can join us in tonight's discussion. So once again, please share this program so that we have the widest possible audience. I see we have a few hundred persons already online joining us. Welcome. And of course, more of you will join us as the program continues. I want to begin by speaking a little on the ruling of the Chief Justice today in the Clifton Hickins case. As many of you would know, Carol Joseph, an executive member of the People's National Congress and a senior executive of the APNU-AFC coalition, filed legal proceedings during the course of last year seeking to challenge the extension granted by His Excellency the President to Acting Commissioner Clifton Hickins' continuation in office as performing the functions of the Commissioner of Police after he attained the age of 55. In short, the applicant, Carol Joseph, concedes that there is a power vested in the President in law to extend the life or the tenure of a police commissioner. However, they contended that that power vested in the President only relates to a substantive police commissioner and that it does not apply to a person acting in that office. They contended that upon the attainment of Mr. Hicken of the age 55 years old, he automatically became a civilian and could not have benefited from any extension whatsoever. They contended that the extension granted by the President, therefore, was contrary to law, contrary to the Constitution, ultra vires, and unlawful. The Chief Justice ordered written submissions on the matter, and we submitted, both sides. We argued that there is no difference in terms of the substantive commissioner when compared with a person acting in the office of commissioner in relation to the powers that that person would be exercising, the benefits and privileges that the person would enjoy, and obviously, if the Commissioner of Police's tenure can be extended, then certainly there is nothing in the Constitution, and there is nothing in the Constitution Prescribed Matters Act, the act that allows for the extension, that draws a distinction between an acting Commissioner of Police and a substantive Commissioner of Police. In fact, the Constitution itself defines a police commissioner as any person performing the functions of that office or acting in that office. So the Constitution itself does not, in any form or fashion, draw a distinction between an acting commissioner as well from a substantive commissioner. In fact, when one checks the appointment process of both the substantive commissioner of police and the person appointed to act in that office, the appointment process itself is identical. The president must engage the leader of the opposition in meaningful consultation. When you look at the powers of the Commissioner of Police in law, the same set of powers are exercised and exercisable by the holder of that office, whether that holder was substantively appointed or was appointed to act in that office. When one looks at the removal process, it is identical as well as it relates to a Commissioner of Police substantive as well as an acting Commissioner of Police. Why then would an acting Commissioner of Police not enjoy the same benefit of an extension that a substantive commissioner will enjoy? And that's a simple question that they were unable to answer. And we showed in our submissions that there is absolutely no difference between a police commissioner, substantive, and an acting commissioner in respect of an extension of the tenure. And the Chief Justice upheld our submissions and dismissed the case. Now, I want you to reflect upon the apparent obsession that the joint opposition seemed to have with Mr. Clifton Hicken. Here, the challenge is not filed by a citizen, an ordinary citizen of Guyana. This challenge was filed by Carol Joseph, an executive member of the PNC, an executive member of the coalition, the APNU-AFC coalition. You would also recall that when Mr. Hicken was first appointed by His Excellency the President to act in the office of Commissioner of Police, another challenge was filed. At that time, it was filed by Christopher Jones, another executive member of the PNC, a sitting member of Parliament of the APNU-AFC coalition government, coalition in the Parliament. I repeat, when His Excellency appointed Mr. Clifton Hicken to act as Commissioner of Police, there was a challenge filed. At that time, it was filed again by Christopher Jones, an executive member of the PNC and a sitting member of Parliament of the APNU-AFC coalition. On that occasion, their contention was that there was no meaningful consultation with the leader of the opposition. On that occasion, we were able to show that at the time when Mr. Hicken was appointed, there was no opposition leader to consult with, as Joseph Harmon, who was then the opposition leader, had resigned. And there was a hiatus in that seat until Mr. Aubrey Norton was appointed. And when Mr. Aubrey Norton was appointed, by the time Mr. Aubrey Norton was appointed, Hicken was already appointed. So there was no one to consult. So they lost that challenge as well. But I go back to the issue. What is this apparent obsession by the opposition with Clifton Hicken? I draw your attention to even prior to them being in the opposition and while they were in government. Mr. Clifton Hicken was the most senior member of the Guyana Police Force after the departure of Mr. Silal Prasad. I repeat, after the departure of Mr. Silal Prasad, Mr. Clifton Hicken was the most senior member of the Guyana Police Force. Yet, he was overlooked for appointment to act even as Deputy Commissioner of Police, or act in the Office of Police Commissioner, or substantively appointed as Police Commissioner. He was overlooked, and ranks junior to him were elevated above him and given positions higher than Mr. Hicken. I ask again, why are politicians hounding public officers? And that's the question that you have to ask here. And I believe that this is a clear case. I have just laid out the facts for you. You can draw your own influences. But it shows the interference or the attempt to interfere with public officers in the discharge of their functions. It is of some relevance also that President Granger was declared by the court on 2 occasions, declared by the court to be interfering with the functions of the Police Service Commission and the Public Service Commission in the discharge of their respective functions. And these are independent constitutional commissions. Mr. Granger was found guilty by 2 different Chief Justices to be violating the Constitution when he instructed letters to be written to these 2 commissions halting the promotion of police officers in the case of the Police Service Commission and halting the promotion of public servants or public officers in the case of the Public Service Commission. Again, you see the authoritarianism of APNU, PNC, AFC as they try now out of office to interfere with or carry out a vendetta against a public official whose functions are not political, whose functions are in accordance with the Police Act and the Constitution of this country. Here it is, an opposition party in the National Assembly, a political opposition, seem to be displaying some type of vendetta or obsession with removing a person performing the functions of Commissioner of Police. Perhaps it is because there is a progressive reduction in the crime statistics. I don't know. The PNC has always had a long alliance with criminal elements in this society. I can refer you immediately to the draping of the flag of Guyana over the coffin of a notorious criminal, Blackie London. I can remind you of guns from the army handed over to the YSM, or guns from the army and the guns from the army missing and found in the hands of criminals. I can point to PNC leaders and supporters declaring that the notorious 5 escapees from the Camp Street jailbreak of 2001 being declared as freedom fighters. I can point to PNC leaders going into Buxton during the crime spree and meeting with criminals. Is it that because they think that Mr. Hicken is doing a good job as a commissioner of police, that they feel this urge to remove him? I am simply putting the facts before you. You draw your own inferences and conclusion. You are quite capable of doing that. Nine new magistrates have been appointed by the Judicial Service Commission, and I want to take this opportunity to offer my warmest congratulations to the new appointees, and I wish them a long and successful career on the bench. I hope that they would discharge the functions of their office as magistrates in accordance with the Constitution, and they would hear and determine cases speedily and in accordance with law. I understand that they have been appointed on probation and that at a subsequent time, their performance will be reviewed by the Judicial Service Commission, the commission that appointed them, and they would be considered for confirmation. It is hoped that these new additions to the magistracy will bring great reprieve, and the many vacancies that exist in the system are now being filled, that the cases that are languishing in the system will now be heard with some degree of dispatch. Yesterday, I accompanied the President in a very important exercise at Cotton Tree Village on the west coast of Berbice, where we distributed over 180 certificates of titles to residents living in that community who have been living for generations on lands for which they had no formal title. Since 2011, a promise was made by us during an election campaign that we will regularize that community and neighboring communities. And we begun the process since then. We had to abort the process when we lost government, though we continued, or we tried to continue it during the time we were in opposition, but APNU AFC instructed the Lands and Surveys Commission not to offer assistance to the process. The work of the Lands and Surveys Commission is integral to the successful completion of the project. So we had to abort it because of the non-cooperation by the Lands and Surveys Commission based upon the political directions they received from the APNU AFC government. When we got back into government, we resumed the process in 2020, and we are now delivering the titles. Nearly 4,500 titles will be delivered at the end of this process. Significantly, at the engagement, the President requested of me publicly while he was speaking to approach the judiciary and request that measures be put into place for an additional land court judge to be appointed for Berbice, dedicatedly to deal with this process so that we can expedite it, or that a land court judge be specifically assigned the responsibility to deal with these matters so that the process can be expedited. I made contact with the Honorable Chancellor of the Judiciary this morning, and I conveyed His Excellency's request, and I'm pleased to report that the Chancellor has indicated to me that once the commissioners of title or the land court judges are appointed, then special attention will be paid to the applications that are pending before the land court in respect of this process, because this process got to go through the land court by law. And most importantly, that a judge, a current land court judge, will be assigned the responsibility to dedicate specific attention to this process so that we can complete the process in the shortest possible time. So that's good news for the persons, several villages who are waiting. There are about 4 or 5 villages in that vicinity who are going to benefit or who are benefiting from this program. As I've said yesterday at the ceremony, this is not a major part of the government titling program or regularization program. That, of course, is done under the Ministry of Housing. This is just a small initiative that President Ramatar first and now President Irfan Ali has given me the authority to conduct. And it has reaped resounding success. In my speech yesterday, I outlined the number of areas that we have already done work in and the number of villages that we are working on or working with currently to deliver hundreds, rather thousands of titles to persons who have not gotten their titles for whatever reason for decades and have been living on those properties. I said in that speech also, which I believe is worth repeating, that this is what real empowerment is. Not standing at some line top and going on TV and going on social media and talking about empowerment and empowerment. Handing a person a title for their land is real empowerment. And when you look at the areas that we are executing this program in, it covers many, many communities across this country. Communities of Indo-Guyanese and communities of Afro-Guyanese. I pointed out yesterday that we are working in Ansgrove and Dutch 4 where we will deliver 450 titles to 450 families who have been living on lands in those communities since the abolition of slavery, and they don't have titles for those lands. We are working in the backlands of Nabakalis and Victoria to give the farmers leasehold interests for lands that they have been occupying for generations. And we are doing that at several places across the country. That, my friend, is empowerment, empowering people. And we are not talking the talk. We are delivering. We are walking the walk. We are putting the titles in the people's hand. That is how you empower a population. That is how you empower a people. Don't try to tell them that you're empowering them when you yourself lack empowerment. And that's the other thing that I should speak about quickly. Those who are speaking about empowerment are themselves incapable of empowering themselves. When you look at the lifestyle and you look at who they are and what they have accomplished in life, they cannot self-empower. How can you empower others? Maybe I am wrong and my judgment is flawed, but I believe that you can't empower others if you can't empower yourself. So start with yourself first before you start to lecture to others and lecture about others and pretend that you can lead others. Lead by example. Show what you can achieve personally. Show that you have accomplished personally. Then you're qualified to tell people how to live and want to manage the affairs of others. Manage your own affairs and show that you can do so with distinction. Show that you can do so with exemplification. Many of them who are masquerading as leaders and want to lecture people about empowerment and about leadership, their personal lives doesn't show or do not show any evidence that they have achieved any modicum of success. I believe that the first instinct is survival. And if you can't provide and accomplish for yourself, by what system of logic you can do so for others? I may be wrong again. I'm just putting these things out there, and you can judge for yourself whether I am off or I don't want to be too judgmental, but I'm putting the facts out there. You form your own opinion. You don't have to agree with me, and you don't have to come to the conclusion that you think I am coming to. You come to a different conclusion if you believe that I am wrong. So, again, please, I see many of you are here. Please, let's share this live. Let's share this program so that many of your friends and many of the persons on your wall and on your page can join us in tonight's discussion. I want to move on to speak about, a person asked me a number of questions. They asked me to express my view in relation to the increase of the debt ceiling. You know, last Friday in the National Assembly, we amended the law to allow for an increase in the debt ceiling. The opposition fabricated and concocted some conspiracy theory that somebody breached their security and was listening into their conversation in the private room in which they are located in the National Assembly. Well, I don't know who would want to listen to the opposition. People don't listen to them publicly. I don't know anybody who would want to listen to them privately. Certainly, the government has no interest in hearing what they are discussing, because hardly they make sense when they speak publicly, more so privately. So they use that as a basis not to attend the debate. The truth is, I believe that they were completely unprepared, and in their usual incompetence, they decided not to participate. I believe that they were incapable of constructing sensible arguments. Because the first thing that I would have had to confront is that while they were in government, they increased borrowing without extending the debt ceiling limit. They borrowed over and above the extant and prevailing debt ceiling limit without disclosing it. So rather than come to the Parliament, as they are required to do by law, and transparently and accountably bring an amendment to extend the ceiling limit for borrowing, they decide to surreptitiously borrow and hide that from the population. And we have the evidence which we have made public. They exceeded the overdraft facilities at the central bank way and above what the law says they could have done. So they violated the law and extended our national liability beyond what the law permitted. And they hid that from the country. The same way that they hid the 2016 oil contract from the country. We got that oil contract, as you may recall, way into 2017. Then we knew about an oil contract in the first place. They hid the oil contract for nearly a year and a half. Then secondly, it is only when we got the oil contract 1.5 years later, then we realized that a $18 million signing bonus was paid. They hid that as well. That money was supposed to be paid into the consolidated fund and reflected in the national accounts of the country and laid in the Parliament. They hid that $18 million from the population, as you well know. And then when Winston Jordan was asked about it, he said he thought it was a gift. He thought that it was a gift. I'm not making up these things. You know that. This is the actual public record. This is what actually transpired. So they would have had to first face that argument, and I think that they can't overcome that. The second argument that they would have had to face is that if, when our GDP was of a particular size, we were borrowing at a particular limit. When our economy was growing at 4.5%, we were borrowing at a particular limit. Now our economy is growing at nearly 50%. Our economy, our GDP has grown exponentially. Our budget is now many times more than what it used to be. We are now classified among the 10th fastest growing countries in the world. Therefore, our ability to earn and to repay has increased exponentially. Does it not logically follow that we are now qualified to borrow more to develop the country? First of all, and that simple logic, they would not have been able to answer. They would not have been able to tell us why borrowing is bad. Because borrowing is not bad. I don't know of any person who was once poor and became rich without borrowing. I don't know of any country that has developed from one stage to another stage without borrowing. One of the greatest countries in the world and one of the largest economies in the world is the United States of America. United States of America has perhaps one of the highest national debts in the world. If you're earning $500, your capability to borrow would be limited or based upon that $500 per month. If you're earning $20,000 a month, your ability to borrow would increase correspondingly. And if you go to the bank, when your salary was $150,000 a month, the bank would tell you, listen, Chief, I could only lend you $40,000. But if your salary increased to $500,000 and you go to the bank will tell you, look, I can lend you up to $100,000 based upon your income. So borrowing is a good thing. What is bad is when you borrow unsustainably, when you borrow recklessly, when you borrow irresponsibly, and you are not able to pay back. And the PNC, as you know, has a long record of that. When we got into government, we were the most indebted country in this hemisphere. And we were bankrupt and was the most underdeveloped country in this hemisphere. What that means is that we accumulated a huge mountainous debts, but we had nothing to show for it. As I said, just go back 5 years. 2015 to 2020, they spent $1.3 trillion in 5 budgets, and what do they have to show for it? What do they have to show for it? They borrow billions of dollars. What do they have to show for it? Yes, we are borrowing, but we can point to a Demerara Harbour Bridge under construction. We can point to a Quarantine River Bridge that will soon start. We can point to a gas to shore project that is ongoing. We can point to multiple highways. We can point to 12 hospitals. We can point to so many things. And what is even worse is that our debt to GDP ratio is one of the best in the world. Our debt to GDP ratio is one of the best in the world. So, take for example in 1991, our debt, was 617% of our GDP. It means that our debt was 600 times the size of our economy. In 2015, it was down to less than 40% of our economy. Our debt was less than 40% of our economy. You know what it is now? 24%. Our debt now is 24% of our economy. You know what's the international global acceptable standard? 49.7% or 50%. We are only 24%. Let me repeat that. 50% is the acceptable standard. 50% of debt to GDP. We are at 24%. We are half of that. These are arguments that they could not have answered. So they could go outside of the parliament now and talk by themselves. They can't stand up and debate these things with us. And why we have to borrow? Because we want to accelerate the transformation of our country. As I've said to a public meeting recently, we are 50 years behind every other country in the Caribbean when it comes to infrastructure, water, electricity, etc. About 50 years behind. We have catching up to do. We can't go through conventional methods. For the first time in the history of our country, we have the ability to move and traverse along an accelerated path. Why not do it? Why not give our people the opportunity to live a better life now while they're alive, while we prepare for a future? And that is why we are borrowing more, because we can pay back. There was a time when we couldn't borrow because we couldn't repay. Today, we have moved, and that's where the PNC left us. We have moved to a different position. And those are the same reasons that we have amended the National Resource Fund Act, to be able to draw down more to spend in the developmental drive in our country. If you have a house that you have had since 1966, and you always wanted to repair this house, but you never had the income to do so. The roof is leaking, the window falling off, the floor falling apart. You don't have proper water. You don't have proper electricity. The fence falling down, the stairs falling apart. Would you not want to repair that house? Yes, you would. Now, if you have $100 million in the bank, would you keep the $100 million in the bank and continue to live in a house that's falling down? Or you will take the money and repair the house so that your family and you can live in greater comfort? Why keep the money in the account when we can use it to accelerate the developmental agenda and the transformational agenda of our country? And that is a simple reason why we have decided to increase the government's ability to draw down money from the fund. And of course, everything is being done in a transparent way because all of it is going through the National Assembly for everyone to see. Every dollar that we are drawing down will be passed to the National Assembly, and we will explain what use will be made of it. It is as simple as that. And that is why we have amended that act. And our finance minister said that in the budget speech. On the one hand, we are being criticized for borrowing more. On the other hand, if we don't borrow more, where will we get the money from? We have to take it out of the fund. We have to take it out of the account that we have. So you can't tell us we can't borrow and then we can't draw there. Then you really want to stagnate the country. You don't want the country to be developed. But that is the agenda of the APNUAFC. They would stand and block progress anywhere. They have done so repeatedly, in government and out of government. When they were in the opposition with a one-seat majority, they voted down the Amaila Fall project. They voted down the specialty hospital. They cut many, many developmental projects across the length and breadth of this country. And they were out of government. And when they got into government, they did nothing. I give the Durban Park example. I give the roundabout. You ever hear a roundabout develop a country? You ever hear a pedestrian overhead crossing that they built on East Bank? You ever hear that develop a country? But they like this pomp and ceremony, a big 50th anniversary celebration. When they got into office, they had a big inauguration fete at the stadium where they blew out $50 million. Then after that, they went to the Pegasus and they had an inauguration ball. And then the next thing they did, they raised their own salary by 50%. And that is what defined the rest of their performance in government. Again, you can go and check the statistics for yourself. They had inauguration ceremonies all over North America. They had in Toronto, they had in Brooklyn, they had in Atlanta, they had in Washington, D.C. That was their priority. Celebrate and sport and so on. And when they're tired and they come back, the next thing they did is to raise their own salary by 50%. Not public servants, not anybody else, their own salary. And again they hit that. We took about 4 months before we were able to find it published in a small publication in the National Gazette, official gazette, because they were required by law to raise their salaries by a government order that the law says they must publish. And they published it in a very minuscule publication that we fortunately were able to find. When the news first broke, Raphael Trotman is the one who denied and accused the Time newspaper of misleading the country. There was a big article about it. Denied and accused the Times newspaper of being malicious. And then we found the thing in the Gazette. And it was the truth. It was the truth. So, my friends, the reporter who asked me to speak on these two matters, I hope I have addressed them fully for you. The reporter also asked me about the provisions that we are going to change in our company law. Well, first of all, let me begin by saying that the Companies Act was passed in 1991. So it is nearly 35 or 40 years old. And by sheer passage of time, it requires a review. Secondly, the state of the Guyana economy and the state of the commercial sector of Guyana in 1991, when that act was passed, was radically different from what it is now. So a law that governed that kind of commercial environment can't properly govern and regulate the type of commercial environment that we have now. So it's a complete overhaul of the Act. In addition to that, there are several realities that have changed globally regarding commerce, company, and commercial activities that our law was never updated to incorporate and embrace. We have to bring those new concepts into company law. For example, anti-money laundering and the countering of financing was not an issue in 1991. Our Companies Act is therefore silent on crucial issues such as that. The stock market that we are hearing a lot about was non-existent in Guyana in 1991. We have a stock market that we are going to reform as well, and I'll speak about that at a different time. So these are many of the issues that will be addressed in the new companies law. And we are using a CARICOM model. CARICOM has done a model for Caribbean jurisdictions. And once there is a Caribbean model, we will try to use it as far as possible. But let me just explain to you the growth that have taken place in businesses and companies in our country from the year 2020 to now. From 2020 to now, we have had 59,014 new businesses registered at the Deeds and Commercial Registry Authority. 59,014 new businesses from 2020 to now. And I have the breakdown every year, year after year. For companies, we have had 4,856 new companies incorporated from 2020 to now at the Deeds and Commercial Registry Authority. That is the rate of businesses establishing and companies being incorporated in Guyana. So you could imagine the growth that we are experiencing in the commercial sector. Definitely we have to get new laws and new regulatory framework. Of course, the activities themselves in the commercial sector have significantly changed, they have expanded, and there are new activities that were never here before. We have a new oil and gas sector, multi-billion-dollar oil and gas sector. Was not here before, was not here in 1991, certainly. Our companies law, our company laws, our Companies Act must take into account these new realities. I am quickly running out of time, so I want to spend a few minutes on the strike being carried out by the Guyana Teachers Union. Now, I've posted this afternoon on my Facebook page a chart that lays out the remuneration of teachers. No, don't put it up yet. Before I get there, people have asked me, why is the strike illegal? First of all, let me say that the right to strike is a fundamental right guaranteed by our Constitution. You have a freedom and a right to strike. But you must have also a basis to strike. Every right and every freedom must be exercised responsibly and have conditionalities attached to them. These actions must also be based upon good faith and not be driven by politics or other ulterior motives. The main protagonist in this strike is a politician, Coretta MacDonald, an APNU AFC member of parliament. She is on TV whole day prior to the strike and now as the strike is going on, giving political commentary all day on the social media about the strike. So there is no doubt in my view that the strike is politically driven. If you look at all the politicians on the opposition, they are all speaking about the strike. Not one of them has expressed any disagreement with anything that the union has said so far. So there is no doubt that there is complicity between the union and the opposition. Then you have racism and division being sown in the strike rhetoric. And you look at them carefully and you see. Coretta MacDonald is incapable of not descending into divisive politics on any given matter. The strike is no different. But most importantly, the government and the union were speaking. They were engaging. I am informed by my colleague, the Minister of Education, that as of last week, the union and the ministry were in discussions. The union had made some demands, and I'm told that more than half of those demands have been met. And the other half are being considered for implementation, are being considered, and whatever is accepted will be implemented. There was no prior notice, there was no known breakdown of the talks, and then out of the blues, the strike action arose. And up to now, we are not clear what is driving the strike. They say remuneration. Well, I looked, and that's what I was talking about. I published a chart on my Facebook page, and I invite you to look at it carefully. I have the chart here, and I confirmed from the Minister of Education just before I came on the program whether the statistics here are correct. Now, in 2019 and 2020, when we took government, the trainee teacher salary was $12,466 a month. So Coretta MacDonald party, when they were in the government, they were paying trainee teachers $12,466 per month. You know what it is now? $104,000. $104,000 a month. $91,537 increase from just 2020 to now. 91,000 from 12,000. Then you have all the teachers. Look at the chart carefully, and you will see almost straight across the board. You will see the size of the increases that they have enjoyed. Now, I don't want you to look at it in isolation. Look at it and compare it with other public sector employees. Look at it, compare it with our police. Look at a graduate teacher and compare it with the salary of an inspector of police. A graduate teacher, trained graduate teacher, is taking home $237,736. $237,736. This is the salary of a trained graduate teacher. Now take that along the line and check what's the salary of an inspector of police or a management level staff in the public sector. And they get duty-free concessions. And they stay home whenever there is a school holiday. They stay home 2 weeks for Easter, 3 weeks I think for Christmas, and 2 months during the August holidays. And whenever there is a school holiday. And I'm not even getting into their lesson fees. All I am asking is, you got to compare it with the rest of the public sector employees. And tell me if you do not agree with me that there is another motive at play here. It cannot be. And it cannot be conditions, because these conditions, when you compare it with the other public sector employee, are quite frankly superior. Very superior. And a regime for duty-free concessions are going to be implemented soon, beginning from I think this year, whereby if you have not reached the status of being a senior mistress or master, but you are coming to retirement age, you will still get a duty-free concession. You will still get a duty-free concession to purchase a vehicle. When you look at the chart and look at the remuneration package, and you can come to your own decision. And I ask you to compare it. Don't look at it in isolation. Compare it with other public sector employees. And that is what a responsible government has to do. Teachers are public officers. Look at our nurses. Compare this with the nurses. Compare it with the police. Compare it with the other sectors in the country. And you will see what I'm speaking about. So, my technical operator is signaling to me that we are coming quickly to program time. So I thought that I'll share those statistics with you. And after the program, consider it. Look at it, examine it, and you come to your own conclusion. As I said, this program is to provide you with information, provide you with food for thought, so that you can come. I don't want to persuade you in any direction. If I do that, well then that's good if I persuade you in my direction. But that's not my objective. My objective is to put you in a position where you are better able to assess the information that you have at your disposal so that you can better make informed decisions. I want to thank you very much for the past hour that you have spent with me. I believe that we have covered a great width and breadth of issues, and we have done so reasonably expansively. Until I see you next week, please take care of yourselves and join me next week as we continue this important discourse in relation to issues in the news. Thank you very much and take care.